Today, we are discussing sexual harassment investigations. And we're going to meet a foreign graduate student by the name of Julie. She is visiting student at Memorial University and pursuing an advanced degree. And she's left her friends and family back home in China. And here she is in a new country trying to learn a new language, adjust to a new culture and a new way of life, and focus on her thesis and ultimately earn her degree. And in the midst of all that change, in the midst of that adjustment, her supervising professor takes a liking to her. And he starts commenting on Julie's appearance and then engages in some other behaviors, touching, that starts very gradually. First, he caresses her face, and that continues on for a period of time when he's complimenting her on her work. And then that graduates to him massaging her shoulders and then her back. And eventually he starts touching her leg and then running his fingers up the inside of her leg and touching her underwear. All of these behaviors make Julie uncomfortable, and especially as they escalate, she becomes more and more uncomfortable and finally files a complaint with the university's HR department. You can see from Julie's situation just how complicated these situations are for HR departments as these behaviors escalate over time and employers are left to unpack that event, put these facts in context, and ultimately resolve the situation. We're going to take you through the sexual harassment investigation today and unpack those issues for you, provide you with a roadmap that you can follow as you complete these investigations, and point out some pitfalls that you should avoid along the way. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers who specialize in conducting workplace investigations and helping you to create healthy workplaces through investigations, training, and advice. When it comes to sexual harassment investigations, we're often dealing with overlapping jurisdictions. So you've got the internal investigation that you are conducting. And if we are dealing with professionals, regulated professionals, you may have a teacher or a physician who's involved in their regulatory body might be conducting an investigation into the alleged misconduct. And depending on the behaviors in question, there may be a violation of the criminal code, in which case the police may be involved. And with all of these different investigations going on, or at least being contemplated, one of the questions that we're often asked is, Dorian, if the police are involved, do I even need to investigate? And the short answer to that is yes, you do, because you have to keep in mind that as an employer, you have an obligation to provide a workplace that's free of violence and harassment. So you have to conduct that investigation to make sure that you are providing a safe work environment. These other folks that may be involved or are contemplating an investigation, they're all looking at the same situation, but they're looking at it through a different lens. So the police, they're approaching this from the perspective of, has a crime been committed here? Was there, for example, a sexual assault? And do we have enough evidence to prove that there was a crime beyond a reasonable doubt? So they're looking at this again through that criminal law lens. And then they have to prove this event at a higher evidentiary burden of beyond a reasonable doubt. From the employer's perspective, you're conducting this investigation to determine if there's been a violation of your workplace policies or any applicable statute. There's human rights legislation and occupational health and safety legislation, and you want to determine, have these things occurred on a balance of probabilities? So is it more likely than not that this event occurred in the way that the complainant is describing? So you're looking at these things again through a much different lens, and for that reason, you have to honor your own legal obligations to conduct an investigation, whether you do that internally or with the help of an external investigator. One of the unique aspects of a sexual harassment investigation is recognizing that victims of harassment, suffer damaging and long-term effects from their experience, and that then informs how you go about the investigation, from conducting your interviews to collecting evidence. The other important point for HR to keep in mind as well is that this isn't just about the complainant or the victim of harassment. There's also another party here, and especially at the outset of the investigation, you want to understand and recognize that the responding party who is accused of sexual harassment can also suffer very long-term and damaging effects, to the reputation and their career at the end of it. If these allegations are upheld, again, there's a reputational impact there. Their ability to keep their job either with that existing employer or to secure new employment is in jeopardy. So you want to make sure that you're setting up a process where both parties are going to be treated fairly, and you are going to be led by the evidence as opposed to believing the victim from the outset. So you want to be sensitive to the needs of both parties and set up a process that will stand up to scrutiny. How do you do that? Well, always refer back to the basic principles of fundamental justice. You want to, as a party to an investigation, you want to have that right to be heard by an impartial fact finder. So someone who's going to listen to the evidence and treat you fairly, who doesn't have any skin in the game, so to speak, who doesn't have any motivations to make a finding one way or the other. Someone who's really going to give you a fair shake, listen to your story, vet the evidence, and come to an honest conclusion after weighing that evidence. For the responding party, you want to make sure that you receive the allegations, that you understand what the case is that you've got to meet, right? What are these allegations, and what do you then need to do to prepare for your investigation interview? What evidence do you have to collect to put your best foot forward? You want to make sure as an employer that you're giving both sides an opportunity to be heard. So you're not just relying on the written complaint that you receive from the complainant. You are meeting with them and hearing and understanding their story and making sure that you're aware of all of their allegations before you start the process. And you want to make sure you're spending equal time with the responding party to, again, make sure that they have received the allegations and that you are giving them time to speak to each one of them and put their evidence forward in response to each of the allegations. And then at the conclusion of the process, whoever is investigating and hearing this evidence, that they're the ones who are putting the pieces together, weighing that evidence and making a determination. You don't have one person actively conducting the investigation, and then somebody else who hasn't actually heard the evidence making a decision in terms of who's credible and whether or not there's actually been a policy violation. One of the mistakes that we often see made in investigations, and especially sexual harassment investigations, is with respect to the selection of the investigator. So you may have set up a process that treats the parties fairly and that follows those principles of fundamental justice that we outline. But then if you select an investigator who has a relationship with the parties and who may either be biased, or at least there's that perception of bias there, that is something that casts a cloud over the investigation itself and then over the conclusions. And along with that selection of the investigator, you want to look at not just are they what's their relationship to the parties, and are they neutral, but then do they actually have the experience to conduct a sexual harassment investigation? There was a case in Elgert and Home Hardware where you had a manager accused of sexual harassment. The company uses an internal person for the investigation. That manager goes out and he conducts an extremely flawed investigation. He actually doesn't have any experience, although he's conducted investigations in the past for the company, he doesn't have any experience conducting a sexual harassment investigation. And he goes out and calls the responding party into an interview, never tells the responding party what the meeting is about, doesn't give him any of the allegations that have been made against him, basically sits him down, tells him that he's accused of sexual harassment. And when the individual asks for details or who's involved and who's made the complaint and what's the context, he's just told that he doesn't need, the investigator doesn't need to provide that information because the respondent knows full well what he did. And the process just goes downhill from there. And not surprisingly, there's significant damages that are awarded against the company as a result. So again, you want to make sure in terms of the selection of the investigator, whether that's an internal person or external person, that that they're neutral in doing that work and that they have the experience and the expertise to help you to do a good job and to put the pieces back together after the process has concluded. When it comes to a sexual harassment, let's understand, what that entails. So oftentimes it's comments on appearance. It could be, demands or threats for sexual favors. We discussed the situation of the graduate student, Julie, at the outset of this presentation, and you have touching of a sexual nature. It may not be that way at the beginning, but you can see the escalation in that behavior, and then it graduates to falling within that definition of sexual harassment. You also have text messages and these that are exchanged between parties, and that may include graphic images or not. There's a case that recently came out, a new allegation against the Chicago Blackhawks, where you had a coach who sent a graphic image to a player, and that was an allegation that was not investigated by the organization. So you do get graphic text and communications by email that often lay the foundation for sexual harassment claims. Oftentimes with these cases, the sexual harassment, it involves a power imbalance between the parties. And so if we look at Julie's situation, here she is, a foreign student in a new country, learning the language, studying under this professor who is her supervisor, and really needs her approval. She needs his approval and him to help her along in her studies and to give her a good grade on her thesis in order for her to graduate. And in that power imbalance, the individual student was vulnerable to these advances that the professor was making over time. And so you often see the situation where, whether it's a professor or student, or it could be a senior executive and a manager, where, if you do this for me, there's a quid pro quo there, where, if you do this for me, then, things will go well for you, right? Or if you, don't do this, then, I'll refrain from granting you this benefit or this promotion or whatever the case might be. So in the case of Julie, she's afraid of graduating. She's like, if I don't go along with this, what does this mean for my future education? Does this mean that I might not graduate? And it's that power imbalance that allows things to escalate and persist over time before a complaint is filed. When we look at Julie's situation, it's not dissimilar from other situations that you'll find in your workplaces. Oftentimes the complainant in a sexual harassment case, there's multiple issues there. And, some of the identity factors that you'll see present include, racialization. There might be an issue there of sexual orientation or gender expression. Oftentimes you're dealing with individuals who have experienced trauma in their past, and that makes them more vulnerable to being taken advantage of, many years later. So again, these are just things to look out for as you're putting the pieces together in the investigations or the complaints that come across your desk. This helps you to understand a little bit of the makeup of the folks that you might be dealing with. So you might be asking the question, well, Doreen, what do I do? Either at the point that I receive this complaint, or even beforehand, how do we prevent these things, these situations from happening? And that really gets back to answering the question of how safe do workers feel filing a complaint. We've just reviewed some facts that these situations persist because of the vulnerability of one party in comparison to the other, and the fact that these vulnerable individuals then are taken advantage of, or it's easy for them to find themselves in a situation where they're taken advantage of, and they're worried about their future. So whether that's their continued employment or graduating, there's something that they feel, so whether that's real, it's a real overt threat, or just perceived, they are in this situation and they feel as if they're all alone. And so as an employer, what you want to make sure you're doing is creating a safe work environment and making sure that workers know that they can come forward with a complaint, that those complaints will be taken seriously and will be followed up on, and that they are not alone in that situation. One of the services that we provide is to conduct an assessment for employers. So even before you receive a formal complaint that something bad has happened, or whether that's sexual harassment or something else, you can conduct an assessment to essentially take the pulse of what's happening in the workplace. And that information, that targeted investigation can be really helpful in terms of providing feedback to employers and helping them to understand where there may be vulnerabilities and what they can do proactively to address them. When it comes to the trauma that victims experience, it's helpful for us to start with the definition. And so we have this definition from the Center for Addiction and Mental Health that defines trauma as the lasting emotional response that often results from living through a distressing event. When you are conducting a sexual harassment investigation, you want to take a trauma-informed approach. You want to be aware of what trauma does, what are those effects that it has on a party, and then that informs the approach that you take, both to conducting interviews and collecting evidence, and then ultimately interpreting that evidence. So you want to understand that trauma can arise from the subject matter of the investigation. This person has allegedly experienced certain events, and as you go through the investigation to ask them about their experience, there's that in essence a re-traumatization, a reliving of this painful experience. And so it's an understanding or an awareness that just answering questions and having to review these threatening text messages and having to describe what happened in terms of a sexual encounter, those things will be bringing that trauma back to the surface for the individual. You also want to understand that trauma can affect memory. And so that's going to impact maybe some of the details that someone may recall, or the order of events, right? They may not be recalling things in chronological order. So keep in mind, and I can't stress this enough, that a trauma-informed approach doesn't mean that you are taking it easy or being any less rigorous on the complainant, but you want to make sure that you are going through that rigor. You're just conducting this work with an understanding of how trauma is affecting this witness, and letting that inform how you prepare for these interviews, how you conduct the interviews, and how you evaluate the evidence that you receive. So one of the ways that you can create a safe environment for the witnesses, letting them know that you are the process that you are about to undertake, and letting them know, here are the steps that I'm going to follow. Here's the investigation process that I'm going to follow, and letting them know that that you're creating the safe environment for them, you're making it predictable, and that they have maybe some external supports that are available to them throughout the process. And certainly you as the investigator are open and willing and to accommodating them throughout the throughout the investigation process, and certainly during the interviews, and encouraging them to be candid with you in terms of what accommodations they need. Pacing is a big one that we often see, where an individual, again, is presented with a threatening text message. They are reliving the trauma of reading that message and the anxiety and the stress that caused them, and they're reliving that again, and that may cause an emotional reaction. So you're letting them know, hey, look, we can take a break, that we don't need to sit down for a 3-hour interview, that we can break up your investigation interview into smaller chunks, and work at the complainant's pace to get through their story. When it comes to getting through their story, you also want to let them know, just let them tell the story in their own words, right? You don't, in most cases, when we're conducting the investigation, we want to start at the beginning and then hear what happened, and have the individual take us through in chronological order. But again, with a trauma-informed approach, you want to let the individual tell the story in their own words. And then that creates a little bit more work for you as the investigator, because you then have to go back and fill in the gaps and try to put things in the right order. But at least initially, again, you don't want to be interrupting the witness and trying to take that rigid approach of making them tell their story in chronological order. We talked about preparing to ask questions and how those questions are phrased. And so if we go back to our graduate student, Julie, we might ask her, how did you respond when the professor put his hand inside your leg and ran his fingers up under your dress? And we can contrast that with, Julie, when the professor was running his hand up the inside of your leg, did you push his hand away? Right? It's very subtle, but for the complainant, having it asked in a way that takes that inference of blame out of it makes a difference. It reaffirms their trust and makes them trust you as an investigator, for them to continue telling the story, as opposed to them feeling judged and having to defend themselves as they describe the events that they have allegedly experienced. Again, this goes back to the point that we made earlier about, there is a difference between, recognizing the existence of trauma and what that does to an individual, and accommodating that during the investigation process. And there's a difference between that and agreeing that someone has been victimized. So at all times, as you are conducting this process, you want to make sure that you remain neutral, that you are being fair to the parties, and you're not taking any sides and agreeing that anyone has been victimized here. You are implementing a fair process. You are recognizing that an individual may be traumatized, using that trauma-informed approach, but ultimately doing your work with the same rigor and letting the evidence lead you to the ultimate conclusion. When you're going through these interviews, when you're going through these interviews are extremely important, but also in many of these cases, it's the other details that help you really understand the nature of the relationship and help you to make sound credibility assessments. So you want to be able to put all the pieces together, and that includes looking at emails and text messages and evaluating, the consistency of what you know about the consistency of the evidence that you receive from the parties with the evidence that you receive from other witnesses. And so in a case that we just concluded, it was a sexual harassment case where you had one coworker who was in a consensual relationship with a colleague. She broke off the relationship, and he had all of these intimate photos and videos that they had taken while they were together. And then he starts threatening to release them and upload them to a shared folder, so all of their colleagues at work can see the videos and share them with other third parties. So this obviously caused this individual a great degree of anxiety and stress, and she endured that for several weeks before ultimately going to her human resources department. And we were able to work with that employer to recover some of these emails, these messages that were exchanged. So some of the messages were exchanged on the employer's chat application, and we were able to work with IT to recover those messages. And that was extremely useful information in terms of then determining what had happened in that case, and then what steps were necessary as a result. So you want to make sure that you're being led by the evidence, that you are not being convinced by a party. And one of the leading cases on the issue of credibility comes from Farnia and Chorney. And what that decision says ultimately is that it doesn't matter how confidently somebody speaks. It doesn't matter how confident they look and how persuasive they sound. What you're looking for are stories that make sense. How consistent is that person's evidence with the documentary evidence and the evidence that you've received from other witnesses? And does that story, make sense? Looking at this as an informed and a reasonable person. So that's what you're looking for. Ultimately, you're not being convinced by body language or, again, a person's apparent confidence. You're really letting the evidence lead you. And in the case that that I just referenced, where the individual was sending these threatening messages to his former girlfriend, he initially denied the allegations. He said, I don't even have the videos anymore. I deleted those months ago. And, it was very convincing in terms of his denial of what he had been accused of. And then ultimately, we were able to bring him full circle to the point where he acknowledged that he had not been forthright with me, and acknowledged that he still had these videos and photos that he had taken with the complainant, and understood then that that his continued employment was in jeopardy, both because of the steps that he had taken, right, the threatening his colleague, and with that material, but also his lack of forthrightness, his lack of honesty during the investigation as well. So those are all things that an employer will look at in terms of figuring out what is the appropriate response here. And in the case of Julie, the graduate student, the university memorial at university ultimately found that these events happened as described by Julie, and the professor was suspended for a period of 20 days. But that case, went all the way to a hearing, and the union contested the discipline, and they put that investigation under the microscope. So it's very important in these cases, when you're dealing with sexual harassment cases, and given the potential outcomes, it's very important that you get it right. And that includes using the right individual to conduct the investigation, setting up a process that is going to stand up to scrutiny, and then making sure that the investigator is taking the right steps along the way, and ultimately arriving at a conclusion that they can defend, because you might find yourself in court or in front of an arbitrator having to speak to certain decisions that you made along the way and how you arrived at your conclusions. So as you are faced with these situations coming across your desk, again, one proactive step that you can take is to conduct a workplace assessment. And again, we find that to be helpful work in terms of taking the pulse of what's happening in your workplace, and ultimately figuring out if folks feel safe coming forward, and do they trust that HR will protect them in the sense of implementing a safe process for this matter to be investigated, and ultimately taking the appropriate steps on the back end of the investigation. You also want to use these situations, whether it's a formal investigation or an assessment, to understand how did HR perform. Are there things that we did here that we can improve on going forward, and engage in that self-reflection to, again, improve the functioning of the HR department, but also to build trust with the workforce, so they can see that the policies that you've got in the workplace, they have teeth, that these policies will be followed, and that HR is going to do its work honestly. and even at the on the back end of the investigation, that HR is serious about improving and ultimately creating a safe and a healthy work environment. And then the other piece of it is looking at this, systemically. What did you learn from the investigation? Are there, systemic issues in the workplace or the work environment that that resulted in this situation unfolding the way that it did? And looking at what you can do to take steps to create again a healthy and a welcoming environment for your workers. So I trust that that information was helpful to you as you look at how to set up the investigation and some of the pitfalls that you can avoid as you go through that process. Happy to take any questions that you might have regarding this issue, or any other investigation issues that you might have on your plate at the moment. One of the issues that came up in the Memorial University case that I referenced involving the graduate student, and we're calling her Julie, one of the issues that came up in that case was the responding party, the professor. He didn't want to meet face-to-face with the investigator. And he took the approach, after consulting with his union, that he was going to only participate in writing. And so there's a lot of back and forth between he and the investigator about whether or not that's appropriate, that the process in place is for him to meet for a face-to-face interview. And he discouraged that, was ultimately uncooperative. And the investigator, there was some sharp communications that went back and forth. And so one of the issues that the union raised at arbitration was, hey, look, we think that this was a flawed process, that the investigator found in favor of the complainant and really held it against our client, held it against the professor, that he didn't want to meet with her face to face, but that was his prerogative. He was allowed to conduct, to participate in writing if that's his choice. And in looking at the evidence, the arbitrator found that there was no procedure that was laid out that would give the professor the right to dictate that his investigation had to be in writing. And certainly it was open to the investigator to implement a process that she believed was fair. And that included having face-to-face interviews and making the individual aware that, look, the fact that you're refusing a face-to-face interview and insisting on written questions, we can certainly proceed that way, but ultimately this may affect your credibility as we collect this evidence and as we make our conclusions. So that was something that the responding party was made aware of. But again, it shows you some of the pushback that you might receive as you go through this process. You really do have to be strong in terms of understanding the process that you're going to implement and sticking with that, despite the pushback that you might receive both during the investigation and then ultimately, in this case, the union and faculty association pushed it all the way to arbitration. A question that we have here, and it's a great one. What happens if the complainant refuses to file a complaint against the accuser? That's a wonderful question. Oftentimes you'll have folks come into your office and they'll tell you about this problematic incident or event that's happened to them. But then they say, we don't want you to investigate. I just wanted to get this off my chest and let you know what was going on. I didn't want you to investigate. And the reality is that as an employer, you have a legal duty to investigate the problematic conduct in your workplace. So your legal duty is to maintain a workplace that's free from violence and harassment. So you actually don't have the ability to pick and choose what you're going to investigate, right? Once those incidents are known to you, you've got to look into them, right? So it's not just you've got an obligation to investigate complaints of violence and harassment. You have an obligation to investigate incidents of violence and harassment. And because of that, once that incident becomes known to you, even if the complainant doesn't want to participate, you have to let them know that you've got a duty to look into this. And you also want to make them know that, look, depending on the circumstances, if you don't participate, that there could be a negative consequence, for you, the complainant, in the sense that, they're if this is a workplace relationship that you're saying existed, and you don't want to participate to verify the details that we need to during this investigation, and if the responding party denies this workplace relationship, well, the only evidence you're left with as the employer is the respondent's evidence. And if there are no other witnesses, then that's going to dictate, in a way, what your conclusions are. And so even though this complainant's come forward, with these allegations, if she doesn't, participate, then, there may be a finding in that investigation that does not go in her favor. And, she may want to then think about, is that something that she wants? So you want to point out the realities of the situation to the person, and encourage them to cooperate with your investigation and participate. But ultimately, you don't want to allow that person to dictate what you do in response. You need to follow your own legal obligations as an employer, and avoid liability by looking into the matter. Another question is, how should you inform the respondent of the allegations? Should this be in writing, sharing the details? So that's a great question. So what you want to do is inform the individual in writing about the allegations, but the allegations, what that product looks like in terms of, the written product that you're giving the respondent. It doesn't have to be a copy of what you received from the complainant, right? So I've seen employers where they get a complaint from the complainant. They basically take that complaint and hand it over to the responding party. And I would advocate against doing that, because oftentimes what you get from the complainant, may not be thorough. Oftentimes is not thorough and complete, right? There's more that you understand about their allegations after you meet with them. The other issue is they may not have expressed themselves clearly. And it may be a little bit of a dog's breakfast, right, in terms of what that written complaint looks like. So you want to make sure that you take that complaint, meet with the complainant to understand his or her story, and then you want to put their allegations into numbered paragraphs. We call that the particulars of complaint. And you prepare those numbered paragraphs that say, in essence, that give the responding party enough detail to understand what happened. So you want to say, on such and such a day, we were at this team meeting, and at this meeting, you dismiss my comments and refer to me as an idiot in front of the rest of the team. And so that way the person knows that, that this incident maybe happened at a team meeting in July, or whatever the case might be. You want to provide an approximate date and give them enough details that when you meet with the responding party, or when they receive these written allegations, they can then go through their records, and they can, go through their memory, and they can prepare to answer to those allegations. So that would be, the best guidance that I can provide is, certainly receive the allegations and put them in a format that's clear and coherent for the respondent to be able to prepare for their meeting with you. Another question is, do employees need to sign a confidentiality waiver during an investigation, and should they? It's my practice to have employees sign a confidentiality waiver. And so there's actually two products that would go to the parties and to the witnesses. One is a letter at the beginning of the process that indicates that a complaint's been received, and here are the steps that we're going to be taking. Maybe they've retained an external investigator, so then we spell that out, that we've retained pursuant employment law to conduct this investigation into this complaint that's been filed, and so they're aware of the introduction of the investigation. And then within that letter, there's a few paragraphs on confidentiality and the employer's expectations regarding confidentiality. Then we have the confidentiality waiver, which indicates that the individual affirms that they understand and agree to maintain the information in confidence, and they further understand that there may be consequences if they breach confidentiality. And where folks don't sign off on that, especially in this day and age of many interviews being conducted by video conference, we would take steps to preserve the confidentiality. So maybe we would then insist on a face-to-face meeting, make sure that there are no recording devices in the room, and just make sure that, again, that we're implementing a process where, as an investigator, we can preserve confidentiality over the proceedings. But I find it to be a good practice to have folks sign that confidentiality waiver, and if they don't, that raises alarm bells for me. Another question here is whether or not you can have a written procedure requiring face-to-face meetings. You could have a procedure that requires a face-to-face meeting. That again, you want to be clear, whether that's face-to-face, in-person meetings. Again, these days many of these meetings are taking place on video platforms like the one that we're using, so you want to allow flexibility for that. Also, in terms of one of the things that can happen during an investigation is that one party may be on some sort of a disability or a sick leave, and there may be certain conditions where they're not able to participate in a face-to-face meeting, but they are, as an accommodation, able to participate in writing. So that you don't want to take, I don't like taking tools out of the toolbox. I like having an array of options that we can use depending on the circumstances. And I have had very few, but at least a couple investigations where we proceeded with an investigation in writing because of certain limitations that existed. So it's not that there's anything wrong with an investigation in writing, but it obviously takes more time. There's more back and forth because you then have to write out your follow-up questions to the initial answers that you receive, and there's a consequential delay there. But having the written responses can be helpful to move things along. Again, if somebody is on a sick leave and that's the only way that they can participate. Another question we have is, if someone is accused of sexual harassment, they hear about the accusations and they seek information from HR, how much information can HR declare in terms of what was said against them? And this really speaks to that role, right, that HR plays in terms of serving employees and supporting employees throughout this process. And this is a classic case of individuals who are on opposite sides of an issue. So in terms of what you want to explain to this respondent is that at that point in time, I'm not sure to what extent the complaint is known. By that I mean how well understood it is. Is it just a written complaint has been filed and you still have to meet with the complainant? Maybe you're not at the point where you have particulars ready, and so really how much is going to inform a little bit about how much you'd then disclose to the respondent. But what you want to do in that situation is keep things at a high level and to let them know that we're still in the early stages, that maybe we've just received this complaint, and here are the steps that are going to unfold. We're going to unpack this complaint with the complainant. We are going to, you're not even disclosing that person's name at this meeting. You're just indicating that that to the extent that HR has received the complaint, we're going to take steps to understand what those allegations are, that we will then communicate with you, the responding party, to let you know how this matter is going to be addressed, and they can expect to receive a copy of the allegations, that they will be given an opportunity to review that and prepare for any investigation interviews that are necessary, and just let them know that you understand it's a stressful time and that there's a lot of uncertainty, and that you understand that these are serious allegations, but just to reaffirm that the company has a process that it's going to follow, and that the respondent just has to be patient and allow the process to run its course. So you're instilling that confidence in the individual, letting them know that you understand where they're coming from, and you're going to treat them fairly, and that they need to step back and again just allow the investigation process to run its course. And as information then becomes more available to you, you're then able to then send out that letter that I described earlier to the complainant and to the respondent, saying, here's what we decided to do. We're going to investigate this, whether that's internal or external. And here's the person that's going to be investigating it. And here is the steps that are going to follow. And you're going to get a copy of the particulars of complaint. And the investigator will be reaching out to schedule a convenient time to meet. Maybe you're going to be separating the parties in the meantime. So maybe one party is going to be exclusively working from home, or they're to the extent that one person reports to the other, that reporting relationship is severed during the course of the investigation. So there are interim measures that are going to be decided on and then implemented at the outset of the process. So those are all things that you as HR, you want to wrap your mind around before you get trapped into answering questions and giving assurances that may be misleading to that person. Another question is, who receives a copy of the final investigation report? The complainant, the respondent, and the board. I take it the board of directors. So that's a great question. Under provincial legislation, the investigation report doesn't have to be shared with the parties, right? So what you are obligated to do is to share the conclusions of an investigation with the parties, and that fulsome report that summarizes all the evidence and the names of all the witnesses that the investigator met with. So that fulsome report just goes to the employer. Typically it would be the HR person that was spearheading the investigation, or whomever that might be, that would go to the employer, and the parties would just receive the conclusions of the investigation. If you are a federally regulated employer, that's when the complainant and the respondent, they're entitled to a copy of the report, but that's what I would call a watered down or a scaled down version of the report. You have to obscure the identities of the folks that you met with, and make sure that in terms of the reading of the report, that the identities of any witnesses are not disclosed and made known to the parties. So they really are just able to see the allegations and some their own evidence that was provided to the investigator, and then ultimately what the investigator's conclusions are. So much different approaches if we're talking about provincial legislative requirements versus folks who are federally regulated. But in both cases, you want to make sure that you're reporting back at least the conclusions of the investigation, and then the important piece is what comes after that. It's the steps that you take to to deal with the misconduct if there was a finding of misconduct, and then putting the workplace back together after the investigation. That's ultimately how you arrive at a healthier situation. Question: should you always have a witness during conversations where you are speaking with the complainant or the person being spoken of? So it's helpful if you can have more than, if you have a large enough department where you can dedicate a couple of resources. You've got two people that you can dedicate to meeting with a complainant or a respondent. It's always helpful because you can have one person who's asking the questions and the other person who's taking notes of what's discussed, and you're able to then put your notes together and make sure that you've accurately captured what transpired at that meeting. So if you've got the resources to do that, that's ideal. It's not necessary. I conduct interviews on my own, right? I meet with a complainant. I may or may not. In most cases, I won't have an associate with me. Right? I'm just conducting the interview and the investigation on my own. So it's just places a greater responsibility to make sure that you are, taking good notes and that you're recording their evidence accurately, and picking up on the nuance and in their body language, and what questions are causing them trouble, and are they being evasive when you ask certain questions, and are you having to follow up on certain issues where they're not so comfortable speaking about what occurred. So again, I think it's things that a seasoned or an experienced investigator just is able to do naturally, and you're able to kind of balance all these things and do the job. But for those who may not have that level of experience, certainly having another person in the room is helpful, but not necessary. Would you be able to provide an example of a letter that's given to the parties at the outset of the investigation? Yeah, absolutely. Kim, if you send me an email, I'd be happy to provide you with that resource. Arena's asking, is there a process for federal and for provincially regulated is the process for federal and provincially regulated companies the same? And so I think I answered that in a previous question. The investigation process is the same, but in terms of the the product that the parties get at the end of the investigation is very different. So the again, for provincially regulated employers, you do not have to hand over an investigation report to the parties. For federally regulated employers, the parties are entitled to an investigation report, again, with certain information redacted to preserve confidentiality. There are other differences, and Irene, if you have questions about the differences between federal and provincial obligations, I'm happy. Please do send me an email, and I'm happy to unpack that further with you. The final question we have is, what happens if the person who brings forward the concern is not the victim? Who is the complainant to that investigation? This is a great question. So it really comes down to an acknowledgement or an understanding that, especially in cases of sexual harassment, that others are impacted by that behavior, right? When there is an illicit relationship going on in the workplace, it's not just the two individuals involved that are important. It's also understanding the impact that has on others. And I've conducted many investigations where it's actually a third party, right? It's a colleague to these individuals who's come forward saying, look, this thing is poisoning the work environment. These two people have a relationship, and here's how that is impacting us. Here is maybe the favoritism that's shown. When things aren't going well in their relationship, here is how we feel it as others on this team. So the complainant is the person who's come forward to you and filed a complaint, but you're absolutely right that that person who brought the complaint may not be, one of the parties to the relationship. They're a victim of the fallout, from that relationship and the fact of that relationship causing problems in the workplace. So it would still be something that the employer would want to look into, because again, you're there to provide a safe work environment for all employees. So even if this relationship that these two people have is consensual, and the two of them aren't complaining of it, if it's causing a problem for other workers, that's something that you want to look into. Understand, there may or may not be a policy violation or anything inappropriate there, but you still want to look into it to understand what's happening in the workplace and then take the appropriate steps. And again, that's a very interesting scenario that you put forward. So if you want to discuss that further, please don't hesitate to send me an email or connect with me on LinkedIn, and I'd be happy to discuss that further with you. I want to thank everyone for joining us for this webinar today and participating, and through your attendance and also your questions. It's a pleasure to share this information with you and to engage in these conversations. I want to encourage you to connect with me on LinkedIn if you haven't already. I'm always on there and happy to answer your questions. We are going to be publishing our events for next year, including webinars and upcoming workplace investigation training events. So you will be getting an email about those events. And I would encourage you, if you are enjoying this content, that you share these messages, share the invitations with others, and we'd love to continue to build our community here. As this is our last webinar for this calendar year, again, thank you very much for your participation. Wish you all the best this holiday season, and look forward to connecting with you in the new year. Take care, everyone.